So next bill for consideration is House Bill 91, News Source Shield Law. So Chairman Zwanitzer, proceed.
Good morning, Chairman Burkhart and members of the Minerals Committee. Pleased to be here today, and it's been a long morning already, so thank you for the indulgence. It was everybody on the entire road for about a mile got stuck in their driveways this morning. So I am pleased to bring you House Bill 91, News Source Shield Law. It was, I'll say, an old friend of the legislature. I did bring it 2 years ago, passed the House, didn't make it through the Senate. Basically, what it does, a shield law or journalism shield law is a protection for journalists to not have to disclose their sources. Every state besides Wyoming and Hawaii now has a shield law in their books. So we're one of 2 states left. I do think you'll hear from people behind me that this privilege or this immunity is not used lightly and only in the gravest of circumstances. And I do think it is important, maybe paramount in a state like Wyoming where everyone knows everyone. And if there was a type of nefarious activity or something controversial, you'd know it was between 3 or 4 people, and their identity protection would be paramount in those circumstances. So happy to walk you through the bill quickly, Mr. Chairman and committee.
Please.
So on page 2, this just talks about what news information means. And so we're always trying to differentiate, gossip from what's, credible news information. And so you'll see in the definition there, when this would go into 112.701, what news information is: written, oral, pictorial, photograph, emails, and the identity of the source of that information. Then we go into the privilege there in the bottom of page 2. And so this does apply to current or former journalists. So just because you leave the profession doesn't mean they can automatically demand you reveal your former sources. As long as you've obtained that information in 2 ways. You can go search it out from an individual, or they can come to you, right? There will be what we would call a whistleblower come to a news organization and, allege certain things, and the news information source would investigate and before publishing a story or using that to gain information in a news story. So you can there see what news information is on the top of page 3. And these definitions are from other states. We're not reinventing the wheel here. This is all pretty solid law that's been around everywhere since, the late 80s, all through the 90s. We're just about the last state to get on board. And then in some cases, because this language, has been around for 20 years, I know there's some amendments and some talk about adding internet instead of just radio stations and television networks, podcasts, those type of things, I think will be part of the debate today. Moving on there onto page 3, when the news information is obtained, you'll see that we are generally keeping these in what I would say the news realm of newspapers, magazines, wire services. We have included websites, radio stations, and again, it does have to be for news. Then in 112.703, the provisions of law, basically the journalist is responsible for this information, and they get to generally decide what they would consider privileged in a court of law. And further on in the bill, we'll talk more about that. And it basically just nicely says the court, you can't sue somebody, you can't compel them to disclose that information as long as it's valid information and then being shielded from, protecting the identity of that witness or that news source. So you can't hold a journalist in contempt. You can't lock them up in jail. You can't do any things that, we see in foreign countries sometimes when it comes to the privilege of journalism and investigating nefarious actions. 112.704 on privileged communications. Just know that privilege is asserted whether it's the court, the legislature, any agency, executive or legislative branch, private company, etc. The privilege goes away if you'll see, well, that's later on. Let me go back to the top of page 5. This does also apply not just to what we'd consider like the newspaper, but this also can go to like the UW branding iron, shall we say. And so not only is a journalist protected, but their employer. So you can't lock up, the editor of the newspaper if one of their journalists, refuses to disclose a source. Same for students, right? If there's that privilege that's been extended to a student newspaper. The burden of proof is always on the journalist. And so we have had some conversations on what is and who isn't a journalist. But in this type of situation, the burden of proof would be on the journalist to say, hey, I'm a legitimate news journalist and this is legitimate privilege. And so we've gotten caught up, I think 2 years ago, some of our colleagues in the other body, really wanted a very tight definition of what a journalist was. But I tend to go back to that section saying, if this were to go to the furthest levels, they would have to prove the existence of I'm, a true journalist and the privilege exists. There is some exceptions there, right, on the top of page 6, if that information they have will cause an imminent risk of death or serious bodily harm, or if it's being used in a defamation action. So this is kind of, I wouldn't call it a loophole, but it's the catch-all that if you feel like it's just a simple defamation against another person or against their character, there is, a way to demonstrate that you could have that privilege waived in a defamation case, right? So it can't be used both ways, just to go after somebody and then they say that it's only used to defame to me. There's no legitimate news source here. That's a possible exception to compelling that disclosure. There's a waiver in 112.707, so the journalist can waive any level up to what they feel comfortable. If it's out in other places in the media world, that privilege can go away, and it does allow that journalist to basically allow them the level of disclosure to who they want to in certain circumstances. And then we just have a provision in the rules of civil procedure that privileged information is used in the Wyoming rules of civil procedure and the rules of evidence. You'll just see that it's put in there that the criminal, in a criminal case, they would have to understand and follow those rules. It does become effective immediately, and I'd be happy to try to answer any questions.
Okay. Questions for Chairman Zwanitzer? Representative Western.
Thank you, Mr. Chairman. And I think Chairman Zwanitzer, you kind of touched on certainly my concern is definition of journalist. Because if I'm wrong, please do correct me, but as I read this, basically anybody who says that they're a journalist gets this type of protection. It doesn't actually come down to any specifics, any quantifiable, hard metrics that, are bona fides that prove that they are. That I could just simply, be a blogger and not follow journalistic practices, but I could still come up with and say this. And I think that's something, we're talking here now in Wyoming, but that's something that's been an issue nationally with our media landscape, which I will not delve into. But I mean, Mr. Chairman, has there been did you guys at least make any attempt to define journalists, and what did that language look like?
Chairman Zwanitzer?
Chairman Burkhart, Representative Western, yes, many states have a definition of journalists. I would say they are outdated in their shield laws. Many of these passed 20 years ago before the rise of the internet. And it has been a conversation. It was a conversation in the other body 2 years ago on who is and who isn't a journalist. And I think that's where this bill has got hung up 2 years ago. And so we considered putting a definition of journalists, and there are definitions from other states. But instead in this bill, we really tried to define what news is. And so if you keep it to what, ensuring that it is in fact news and not salacious gossip, and it's used at a source, and you'll see there on page 3, the mediums that this would be published in legitimate news publications. The journalist itself perhaps does not matter as much to me as long as it's being, it's some company, right? You're not, whoever's publishing that in the press association, a wire service, even a website, there is someone responsible and an owner, and usually, a corporation, et cetera. And most of these companies, they have professional ethics that they subscribe to, but because it's not a governmental, it's a trade association, right? A society of professional ethics and journalism, it's really tough to put that in statute. So I do think it's perhaps not appropriate to clearly define what a journalist is, because that does change. But I do believe what makes me feel comfortable is if somebody claims this privilege, they would, have the burden of proving they are a journalist. And I would think in those cases where somebody who truly has this information, and it doesn't happen often, right? We're not talking this is a monthly thing. This is a once every 5 or 10 years type of situation. If that person didn't truly feel comfortable they were a journalist, they would go seek out a more lofty journalism source, right? They might partner with a newspaper, with a radio station, with someone else to help disseminate that information. I think that would be the protection in many of these cases.
Okay, follow up, Representative?
Thank you, Mr. Chairman. Representative, Chairman Zwanitzer, but do you feel that this bill draws that clear delineation? Because I certainly appreciate, let's think of the famous examples, the Watergate scandal, the Snowden disclosures. Obviously, this type of stuff absolutely makes sense, but it doesn't make that clear delineation between that type of stuff or stuff of that nature and stuff that perhaps some might deem it quite serious and others might deem it as just simply gossip. And is that delineation made clear enough in this bill, would you say?
Chairman Zwanitzer?
Mr. Chairman, Representative Western, I believe it's about as clear as we can make it. It's probably the honest answer. Do I feel comfortable with where it is? Yes. Do I think it's airtight? No, because of just the ever-changing world around us of what is a journalist and a blogger, and I mean everybody today, can kind of. I don't want people just scribbling notes and then putting them on a social media website and saying, "Hey, I'm a journalist." So there are, I think, professional ethics organizations that kind of delineate what a journalist is, but I do feel comfortable in this bill if we keep it to news information and where that news information can be published, and I'm not as concerned about the definition of a journalist. And again, that catch-all is in the law, that if this went all the way, that journalist would have to prove in a court of law that they are in fact, a legitimate journalist with a legitimate news story.
Okay, Representative Lawley.
Thank you, Mr. Chairman. Representative Swanson, I'm going to always get your name wrong. I'm sorry. But I want to follow up kind of on the same topic. So is your reading of on page 5, the burden of proof provision, you refer to it as a burden of proof to prove you're a journalist, but I'm not certain that's the way I would read the statute. But I just wondered, the way you've defined, you're focusing on the news, is it news gathering, which I totally understand why you did that, but does that affect, in your view, the way on page 3, Romanet 2, that you've defined news gathering? How does that interact with page 5 on burden of proof?
Sure.
Chairman Zwanitzer.
Mr. Chairman, Representative Lawley, and I believe a lot more of it comes on page 5 on lines 15 and 16. It's the burden of proof is on the existence of the privilege. So it's not so much on whether or not you're a journalist or this is a news source. It's kind of the existence of the privilege in itself brings everything into play. So then you go back to news information definition. There would be a lot for a judge to consider, right? We try to keep that definition very broad of any written, oral, pictorial, photographic. And so it is, I think, designed to be very, very broad, but I believe you'll hear from the people behind me who are in this field and do this work every day. This is only used in the most, grave and rare circumstances, and it's certainly not used lightly, and would not be used lightly, right? In Wyoming, we have very few news sources. We have one political reporter for kind of each of the major 5. They can't afford to go too far without being replaced. It's just Wyoming's just a weird place where we all know each other, and there's very few professional journalists engaged in this. So I think there is room for other people to go to, their favorite news site, and people are finding their own news sites these days. But, I think ultimately the issue is if there's something nefarious going on towards a corporation, government, or business, people need to know that information and would hope whoever that person goes to finds a reputable source to get that information out there.
Any other questions for Chairman Zwanitzer? Ready? Okay, Chairman, hang with us if you would. So with that, I will open it up to public testimony. Any other legislators? Anyone from the governor's office? Any state agencies? Okay, the rest of you, please come on up. And if you would identify yourself for the record, please.
Yes, sir, Mr. Chairman.
And
Thank
you
you.
might have to get a little closer to that mic.
You bet. Good morning, Mr. Chairman. Good morning, representatives. My name is Brian Martin. I'm the managing editor of the Wyoming Tribune Eagle newspaper here in Cheyenne. I'm here today to speak in favor of House Bill 91, titled News Source Shield Law. I'm in my 25th year as editor of the Wyoming Tribune-Eagle, and during that time I've had the pleasure of speaking with a large number of Wyoming residents from all walks of life. Many of the people I've come in contact with, I've never learned their name. And they called me to report some concerns to them, but they said they wish to remain anonymous. Some of these callers simply had a bone to pick with a local business or an individual they felt had wronged them in some way. As a professional journalist who's trained with a college degree, both as a reporter and then later as an editor, I quickly had to learn how to tell which of these folks were calling simply to try to use the media to embarrass or retaliate against someone. However, through the years, I've also spoken with some incredibly courageous people, employees of state agencies, enlisted military personnel, school teachers, and federal workers who have seen wrongdoing where they work or fallen victim to sexual harassment or discrimination. Some of these individuals were willing to risk their jobs, their ability to support their families, and their careers in order to expose the injustice or corruption. Others couldn't afford to take that risk, so they asked for a promise from me and a reporter to keep their identity a secret. Until recently, I'd promised that their name and phone number would remain solely in our files, not to be shared with readers or anyone else in the community. I felt I could guarantee that because I was sure that lawyers and the organizations that they represent would respect the anonymous sources who boldly step forward to speak with a reporter. However, I no longer feel like I can guarantee that that would be the case. More and more often, reporters are being subpoenaed and asked to reveal their sources, as well as to turn over their notes from interviews with these types of sources. And yes, it doesn't happen all the time in Wyoming, but it has happened here in the past. Without the protections included in the bill before you today, I can't guarantee that after a fight in court, which we would engage in, I would be able to prevent that person's identity from being exposed. You certainly already know of many of the famous cases where whistleblowers working with journalists have exposed government corruption at the highest levels, and Representative Western mentioned the Watergate scandal being the most famous. But let me tell you about a situation we had here recently in the capital city. Earlier this month, we began hearing multiple reports of people not receiving their newspapers, which since last August have been delivered exclusively by the United States Postal Service. We knew we had delivered all of our papers to the main post office on Converse Avenue by the 3 a.m. deadline, so we were at a loss to explain what was happening. It was only when I heard from a postal worker who asked to remain anonymous that the problem was revealed. You see, according to this employee, who we verified had worked for the USPS for several years, the interim postmaster was engaging in a practice called rolling mail. That meant she was consciously deciding to have carriers not deliver any mail at all in favor of delivering Amazon packages, which could be tracked by barcodes so that the customer knew how long it took to reach their destination. Only by speaking with this postal carrier and verifying their story through screenshots of text messages that they received from the postmaster directing them not to deliver mail and to instead deliver packages, were we able to expose this clearly improper action. Since this had occurred on more than one occasion, I have to wonder how many more times it might have happened that had we not called the USPS in Denver for comment and reported to the community what had been happening. Before the postal employee would speak to me, though, I had to assure them that they would remain anonymous. It was a promise that I certainly would do everything in my power to fulfill, but would be guaranteed by the passage of this bill, House Bill 91. Because there's no federal shield law to protect journalists from being forced to reveal their sources, and Wyoming and Hawaii are the only two states without any protection at the state level, we run the very real risk of not hearing from people who want to expose wrongdoing, like the rolling mail example I just gave. Of course, even though delayed Social Security checks, bill payments, and medications are bad enough, there are in fact worse things that need to be exposed by professional journalists and the anonymous sources who want to expose them. Improper use of public funds, embezzlement, abuse of power, and more happen all the time, but we don't know about it until someone steps forward to tell us about it. As I conclude my prepared remarks, I want to assure you that I and my professional journalist colleagues throughout Wyoming would much rather use sources who would give us permission to use their names. We grant anonymity only as a last resort, after attempting to convince the original source to go on the record and trying to verify the information through other sources who are willing to be identified. Some situations, however, are simply too important to keep from the public, and that's when we agree to allow anonymity. I hope that you will agree that Wyoming journalists use this tool very sparingly, and that both the sources and the journalists they speak with deserve to be protected in this way. Thank you, Mr. Chairman, and members of the committee for your time and your attention to this important matter.
Questions for Mr. Martin? Any questions? Mr. Martin, thank you.
Thank you
very much. Anyone else? Please come on up. Okay, you two can fight about it. If you would identify yourself for the record, please.
I'm the general manager of KCWI in Casper and KGWN here in Cheyenne. Mr. Chair, members of the committee, thank you for hearing from us today. I'm a TV board member of the Wyoming Association of Broadcasters and here representing that organization and my own. The broadcasters of the state ask you to support HB91. News source shield laws are incredibly important if you're involved in the news reporting business, such as our TV stations. The news gathering profession requires a certain level of trust between a reporter and those sources are frequently concerned with retaliation or punishment when sharing their sources. And those sources are frequently, some of them take big risks when talking to us. We rely on sources, and those sources might not share sensitive or critical information in the absence of anonymity, mostly out of fear they're being punished for sharing it. I understand that some may believe that this is a solution in search of a problem. I would argue that the potential for application of this law exists every day. Many stories begin with confidential sources. That's where our work begins, not where it ends. Verifying what the sources told us, acquiring the publicly available documents, and interviewing the on-the-record sources are part of our process. If reporters can ensure confidential sources' identity, the public may never receive information on critical public safety, public policy, and corporate governance matters. As news reporters, we don't use anonymous sources lightly and use them only when we've explored every avenue available for a named source. If we choose to use an anonymous person, we check and double check to make sure this is a credible informant. This is a practice we use for all news stories. When it comes to a free press, anonymous sources can be very useful. Without them, journalists could simply not do their jobs. We'd be relying on the official side of the story. And the official side of the story isn't always the whole story. On behalf of broadcasters, we ask for your support of HB91. I stand for any questions, Mr. Chair or members. Thank you.
Thank you, Mr. Beck. Any questions for Mr. Beck? Any questions? Thank you very much. Okay, it is your turn now. Even if someone else raised their hand, it was going to be your turn.
I thought you said we could fight over it.
So please identify yourself for the record.
My name is David Iverson. I'm the owner of Cowboy State Politics. I echo the comments of a lot of the previous speakers, including Representative Zwanitzer. It is absolutely essential that we have a free press. In fact, I think the Wyoming Constitution puts it most clearly that, and it's in Article 1, Section 20, that every person may speak freely, write, and publish on all subjects, being responsible for the abuse of that right. And so while I think that we absolutely have to have a news source shield law, I do have a couple of problems with this bill. The first one is in what is the definition of news? And I think that Representative Zwanitzer brought this up. What exactly is news? Do you have to belong to a professional organization, or do you have to work for a newspaper or a television station? I would submit that with the advent of the internet, the definition of what is news has been expanded quite broadly. In fact, my website, cowboystatepolitics.com, I mean, there's an argument to be made that it doesn't fit in the definition listed in the bill. And so I think that we have to find some language to include independent journalists in this bill. The truth is that most big news stories are not broken by your big news outlets. It's generally some sort of independent news source that finds something and then brings it to a larger news outlet. So I absolutely think that we have to include some language to include independent journalists. The second problem that I have with this is with the defamation part of the bill. The truth is many journalists are subpoenaed in defamation cases. And if a journalist is unable to protect their sources, nobody is going to talk to them. I myself, in the first year of my program, published a number of stories that relied on sources that risked their careers, their positions, and their reputation by talking to me. And if I was not able to guarantee that they would remain anonymous, they weren't going to talk to me. And in those cases, a lot of information would not have been made public. And so I have a real problem with the section on defamation. I think that if there's a loophole, any loophole whatsoever, where somebody can go after a journalist and demand their sources, I think that that infringes on the free press. And so with those two objections, first of all, that we have to include independent journalists, and second, that we strike the language referring to defamation, I think that this would actually be a good bill. And I'd be happy to entertain any questions you might have.
Any questions for Mr. Iverson? Representative Heiner, I saw you first, so.
Thank you, Mr. Chairman. Mr. Iverson, thank you for your comments. Do you have some specific language you would propose for amendments to improve this bill as you discussed?
Mr. Iverson?
Mr. Chairman, Representative Heiner, I think that if we could just include "or independent journalist" in the first section that talks about what is news. I mean, I think that that would cover it, and certainly that is broad. But I think that we're dealing with a topic that is broad by its very nature. But I think if, as was brought up by Representative Zwanitzer, that if you have to show that, yes, I am a journalist, then I think that meets any standard.
Other questions? Representative Western, did you have a question?
Mr. Chairman, Mr. Iverson, you said obviously with the internet age, we've seen the landscape shift a little bit, and talking about your website. In reference to your specifically, I mean, what kind of reach are you getting right now? I mean, I know those metrics are pretty easy to identify through your website vendors. If you could maybe talk a little bit about that.
Mr. Chairman,
Mr.
Representative Western, yes and no. The metrics are easy to find out. The reach of the program is pretty much statewide. There's 130,000 downloads, thereabouts, this morning. On any given week, I reach several thousand people.
Okay. Representative Heiner.
Thank you, Mr. Chairman. Mr. Iverson, did you mention that you would recommend striking the whole defamation clause, paragraph, which is subparagraph II on page 6?
Mr. Iverson?
Mr. Chairman, Representative Heiner, yes, it is my opinion that we should strike the entire defamation section.
Representative Lawley.
Thank you, Mr. Chairman. Mr. Iverson, could you read that quote again from the Wyoming Constitution on Free Press?
Sure. It's Article
Mr.
1,
Iverson,
Section,
please.
excuse me, Mr. Chairman, Representative Lawley. It's Article 1, Section 20. It says, every person may speak freely, write, and publish on all subjects, being responsible for the abuse of that right.
Okay. And can I follow up?
Follow up.
Could you kind of help me understand how the latter part of that, being responsible for the abuse of that right, kind of interacts with the defamation part of the statute?
Mr. Iverson? Sorry, Mr. Iverson?
Mr. Chairman, Representative Lawley. Well, we have laws concerning libel and slander. Okay, so we can't, like, anybody can't print something that's not true. And certainly no self-respecting journalist would do that either. So it's my interpretation, being responsible for the abuse of that right relates specifically to libel and slander. That's how I would read it.
Follow up, one more.
Go ahead, proceed.
Why would it not also extend to defamation?
Mr. Iverson?
My objection, Mr. Chairman, Representative Lawley, my objection to the defamation part is that you can file a defamation lawsuit for just about any reason. Now, I'm not saying that they will go forward, but it's very easy to file a defamation lawsuit and then request sources from a journalist through it. And I just think that it's a loophole, and that I think it's one that we need to get rid of, because quite frankly, I think that it could be abused.
One more follow-up.
Follow up.
I'm not sure I
Lawley.
understand the distinction between defamation, slander, and libel in this regard to the fact that anyone can bring it and request your sources. I'm kind of clear on how you're seeing it.
Mr. Iverson?
Mr. Chairman, Representative Lawley, as I mentioned, if you're responsible for the abuse of that right, it means that you're not going to print things, or you can't print things that are untrue, libel or slandered. And as I said, a defamation lawsuit doesn't necessarily have to relate to both of those. I mean, you could, as I said, you could file a defamation lawsuit for any number of reasons, and then it could be requested that you reveal your sources.
Okay. Any other questions, Mr. Iverson? Mr. Iverson, thank you.
Thank you, Mr. Chairman.
Any other public testimony? One last time. Okay, I'm closing public testimony. Committee? Move the bill. Moved by Conrad, seconded by Banks. Okay, committee, we'll just go through this. If there are no comments to start with, page 1. Page 2. Representative Heiner.
Mr. Chairman, I propose an amendment on page 2, line 17.
Okay,
I would propose after current to add a comma, strike or, and then after former, insert or independent. So the line would read a current, comma, former, comma, or independent journalist shall have a privilege.
okay, seconded by Conrad. Mark, are you clear on the amendment?
Yes.
Okay, all right. Discussion? Okay, all in favor, say aye.
Aye.
Opposed, no. Okay, that amendment is adopted. Anything else on page 2? Page 3? Page 4? Page 5? Page 6? And page 7? Okay. Any other amendments or discussion? Committee? Question being called. We're voting on House Bill 91, News Source Shield Law. Mark, would you please call the roll?
Representative Banks,
Aye.
Representative Conrad,
Aye.
Representative Heiner.
Aye.
Representative Knapp,
Aye.
Representative Larson,
Aye.
Representative Lawley,
Aye.
Representative Tarver.
Aye.
Representative Western. No. Once again, I'm sorry. No. Chairman Burkhart.
Aye.
Ayes are 8, noes are 1. This is a do pass with amendment.
Okay. House Bill 191, News Source Shield Law with amendments has passed the Minerals Committee.